Hello, ladies and gentlemen. Welcome to Part 2, not including the introduction of this series where we're going through the constitutional law and we're going through this document, the Occulted Powers of the Constitution. And we've just been talking about the sort of the bigger ideas about what is a constitution, what's it for, what's its purpose, what makes it a good constitution or not. And we've been talking about that. And we just about came to the conclusion that there must be some other mechanism other than voting rights, adult suffrage, that is placing the people in authority over their own government or own administration, because they're, in a way, this situation is bringing about a condition where the government isn't really a government at all. So what is that? And we just got to the point of basically saying in the previous paragraph that this is Judicium Parium in Latin, which is authentic common law trial by jury. Which is not really the kind of trial by jury that we have in place today. It's something different, something much more authentic, something that's got a lot more power behind it. So let's get into it. That's what this is all about. Authentic common law trial by jury. So here we go. Unlike the trial by jury we have today, in which there is seemingly only one purpose to the jury, in authentic common law trial by jury, there was a second purpose that elevated the people in the jury to the highest law council of the land. The petit jury, as it's sometimes known as, of 12, has the right and the duty to judge not only the accused but also the law itself. The jurors are supposed to judge on the existence of guilt in the accused, but not simply by following the legislation under which the accused was brought before them. They must make an independent decision on the guilt of the accused based on their conscience. They are looking for mens rea, malice aforethought. So that's mens rea in Latin is what is known as the state of mind. It's what the legal profession understand that, and the judiciary well, which is that we're looking at the state of mind within the accused. It's known as mens rea. The people form their community's laws by tapping into their sense of natural justice or natural law. Okay, so in the context of the constitutional material, I'll probably go as far as just really calling it, in general, natural justice. And natural justice is this idea that law must stem from the ideal condition of man, the best conditions for man to flourish, and to be the best that he can be. Okay, and law in a sense flows from that understanding of what that would be, to give them liberty. If you constrain man and you enslave them, then man does not display his best qualities. Not as creative, not as productive, etc., etc. So that sort of in essence is what that's about. But natural law is hinting there at a much deeper, more esoteric understanding of that, and that's sort of beyond the scope of this document. And that's the sort of area of material that is going to be dealt with by my other website, lawandalchemy.org, which is that's what that's dealing with, that much deeper understanding of what natural law is. But natural justice, we could think of it as just that in this context. So carrying on. For this reason, under genuine common law, the juror's decision is also private, and there must be no coercion of a juror by the court to reveal their reasons for their conclusion. And that's largely the case even now. You very rarely get a situation where, for some reason, an individual juror is coerced into revealing why they think guilty or not guilty. That doesn't happen. It's very impractical to do that anyway, and you don't really know ultimately who has said guilty and not guilty. They usually do it, obviously, in the deliberation room, but not out in court. So, therefore, that's kind of basically saying that it's a very impractical thing to nail down as to what exactly a juror is saying and what they're thinking, and that's for a good reason. It's meant to be a private decision according to their conscience. Yeah, carrying on. Furthermore, in order for the accused to be found guilty, all 12 jurors must return a guilty decision. Even if the decision of only one juror of the 12 is not guilty, then the overall jury's verdict is automatically not guilty. authentic common law, fundamentally favours liberty, and there is no such thing as a rogue juror or a majority verdict. Yeah, these are things that have been introduced more recently, and it's all to do with reasonable doubt. It's this idea that if there's a danger at all that this man might be not guilty, then it must be not guilty. Yeah, you must favour liberty. It's just a general principle in common law, because you're going to do a hell of a lot of damage by enslaving people who actually never did it in the first place. That's a really bad place to go as a society. Okay, so we've got a quotation here. David Hume describes trial by jury as an institution admirable in itself, and the best calculated for the preservation of liberty and the administration of justice that was ever devised by the wit of man. That's quite a quotation. Yeah. So David Hume's History of England, Chapter 2. That's a fantastic little source, because there are many out there. But that's a great one, isn't it? You know, the best liberty and the best calculated for the preservation of liberty and the administration of justice that was ever devised by the wit of man. I mean, wow, you know, very useful. Right, so carrying on. The jury's verdict can ultimately disagree with the legislation, and this is known today rather patronisingly as a perverse verdict by the establishment. Although there is nothing perverse, of course, for the juror to find the legislation under which the accused is brought before them as unjust, yeah, or unworkable practically, or whatever it is. You know, there'll be some decisions where, in this particular situation, this man is quite clearly in our minds not guilty, or should be found not guilty, even though it's quite obvious that he's broken the legislation, yeah? So, you know, that's an important principle, right, morally. That otherwise, what would be the point of the jury? The jury is there as a council of conscience to decide on this man. And if they feel uneasy about passing punishment on this individual, then it stands to reason that they must have that right and that power to pass a not guilty verdict in opposition to the legislation. Yeah, and that's a fundamental principle that's existed through our history of trial by jury. If this happens, then something must be flawed in the case or the legislation itself, as it is found to be out of alignment with the consciences of the jurors. When this occurs, the legislation is annulled specifically for that case. I think sometimes there's been a misunderstanding that it's at that point. It just takes one decision of one jury, and then the legislation is immediately wiped from the statute books. No, that's not how it works. Okay. Annulment by jury, which is what we're getting on to saying that this is, or jury nullification as it's called in America, occurs within that one case. It's basically, in that case, that piece of legislation is being annulled. That's essentially what it's saying. This is the people governing or policing their own society. So let's have a look at this quotation here. It's actually from Justice Sir Geoffrey Gilbert's History of the Common Pleas, but it's being quoted in Ken Dewdney's book by Ken Dewdney in Democracy Defined, the Manifesto, because he's got some editorials in here, but important ones. So this position that the matter of law was decided by the justices, that means judges, Ken's put there, but the matter of fact by the peers, is wholly incompatible with the common law. For the jurata, the jury, were the sole judges both of the law and the fact. Wow. Okay, ladies and gentlemen, that is Justice Sir Geoffrey Gilbert. Justice, that's a judge, okay, saying that in the establishment, that essentially, right, the jurata, the jury, were the sole judges both of law and the fact. It's a killer. That's an absolute killer quotation. Okay, so Dewdney continues quoting from the same source. The anarchist says that this, i.e. whether the jurors reflect upon the question of law, is indeed a maxim in the civil law jurisprudence, but it does not bind an English jury. For the common law of the land, the jury are judges as well as the matter of law as of the fact, meaning both law and fact. With this difference only, that the judge on the bench is to give them no assistance in determining the matter of fact. But if they have any doubt among themselves relating to the matter of law, they may then request him to explain it to them, which when he hath done, and they are thus become well informed, they and they only become competent judges of the matter of law. Okay, it's an absolute bombshell. And this is the province of the judge on the bench, namely to show or teach the law, but not to take upon him the trial of the delinquent, either in the matter of fact or in the matter of law. Yeah, these are not the only ones. There are plenty of other quotations that talk about this. But that's quite useful, I think you'll agree. So carrying on. The above situation is what is described as annulment by jury, sometimes referred to rather ambiguously as jury nullification, and occurs when a defendant is brought before court. Excuse me. So I've just referred to why jury nullification, the term, is a little bit ambiguous. It's because you haven't got the preposition in there. Okay, so it actually sounds, jury nullification sounds like you might annul juries. It's energetically, that's not a very good way of putting it either. So the term annulment by jury is making it absolutely clear as to what is being annulled and by whom, right? So which is why we tend to prefer that term on my websites, and Ken Dudney, it makes that point very well as well. So it's just a key thing to remember, I think. Carrying on. It is important to draw the distinction, again, between what our current establishment and judiciary call common law, which is known as stare decisis, or case law, that is, law that is decided on precedent, and that of the genuine common law. Now, this is really important because there are organisations in the broader freedom movement that are getting this completely wrong as well. Our current system contains a body of wisdom made up of a series of precedents that are formed from decisions of justices following appeals. This body of precedents does indeed contain some interesting and in many cases excellent and obviously very carefully thought through decisions. But it's important to keep in mind that in order to have such a body of wisdom at all, it would have to be held by the judiciary, an arm of government, the very organisation from which legislation was spawned. That fundamentally breaks the principles of equity on which our rule of law is based. Right, now that is absolutely key, okay? And the legal profession are constantly swapping between using this same definition, common law, to describe, when they say at common law, they're actually talking about proper common law, legem terrae, the law of the land. But they'll also refer to the decisions of justices in appeals, stare decisis, or case law, also as common law. It's absolutely incorrect, okay? And this is really important. Now, that body of knowledge, as I'm saying there, which is case law, is actually really interesting if you read it, and some very, very careful decision-making going on there. However, the important point is that, and I probably should rewrite that bit a little bit, actually, because that case law is good and very interesting, and it can exist. But here's the principle: it must not bind a future jury. Okay, we're keeping this principle here, which is that a jury is not bound by anything prior. Always, okay, because remember that the whole point is that it's a court of conscience. Yeah, so as soon as you try to predetermine law, whether it's in legislation or whether it's in case law, you're still effectively legislating. In a sense, you're trying to predetermine and categorize justice, and that is absolutely contrary to the principles of the Constitution. Okay, so the key phrase there is nothing binds a future jury. And I probably should put that in. Maybe that's for my next revision of the document. So under genuine common law, this body of case law as precedent cannot exist. Well, actually, that's not quite true. It can exist, but it must not exist as law. Yeah? Which is precisely why not only the judiciary had a much reduced role, but also at the point of annulment, the jury will not be making reference to any previous decisions and are not bound by anything prior to that case. So I have sort of said it actually there. It is purely through their conscience that they are judging the accused. Right, so I've kind of said it actually, but I'd like to put that in there. Nothing binds a future jury is absolutely key there. So moving on. However, a more far-reaching process could lead to the complete repeal of a statute, and this involves the actual prosecution at a jury trial of those involved in the creation or upholding of unjust legislation. This process is known as private prosecution, and importantly, under authentic common law, this would have also been provided cost-free to citizens and could have resulted in the expunging of unwanted statutes. In Article 61 of Magna Carta, it is stated that government officials have no liability protection under the Constitution. Okay, so without that liability protection, it means that people, not vexatiously, can go after public servants. And that means that's a cost-free private prosecution. If you can go after people who've basically been framing legislation that is unconstitutional, that is breaching the liberties of the people, they shouldn't be doing that. Okay, that's unlawful. They shouldn't be doing that. And so that would be ripe for a private prosecution. That would be asking for that, really, to happen. And, of course, bringing that before a trial by jury would then mean that that piece of legislation comes up as the evidence, and then, that's going to put pressure on the legislators to repeal things that would be considered by the people as unconstitutional. Yeah, so that's a really powerful mechanism. You've got to understand that. It's kind of it's trial by jury, full authentic trial by jury in a slightly different context, in a slightly weaponized context, that as well. So moving on. Following contemplation and reflection on this, one can begin to realise the profound nature and power of these mechanisms in conferring liberty on the people. It is these mechanisms that provide the foundation to the term consent of the governed. Because we sometimes talk about that, the consent of the governed. Where does that come from? Well, the consent is provided or not to each piece of legislation through the jury. That's where the consent of the governed is coming from. And it's where that sort of disingenuousness of members of the establishment is coming to the surface there in that, because they need to be challenged on that, really. Carrying on. And so it was that the people ruled the country through the jury, as indeed was the case in ancient Hellenic Greece. The Athenian constitution in the time of Cleisthenes, around 508 to 507 BC, allowed the citizens to be the final arbiter of law through their exousia rights. Exousia meaning authority from the Greek. That's where it comes from. This same principle was adopted all over Gothic Europe, and common law was typical. Indeed, Emperor Conrad of Germany, 200 years before Magna Carta, had established the right of the juror to judge according to their conscience. Right? So this is really important, this. Okay, because 200 years prior to the 1215 Great Charter, we've got almost exactly the same principle as was expressed in Article 39, being expressed by a Roman Catholic in Germany. Okay, this is the Latin here. So it translates into, no one shall lose his estate unless according to the custom of our ancestors and the judgment of his peers. And it's and the judgment of his peers there. And that's written into Blackstone. So, that's pretty key. That's basically saying that this authority of the jury came as a principle well before Magna Carta. These principles were established not only in England, but also in large areas of Europe as well. This was absolutely key. Common law was a key part to that as well. So that absolutely deals with this idea that, Magna Carta is people saying that our constitution was started by the 1215 Magna Carta, but they've repealed that. Well, first of all, they can't repeal it because this principle already existed before that. It was already part of our constitutional law. So Magna Carta was not the beginning of our constitution, right? What it really is, and we'll get onto this later, is that it was just the most up-to-date expression of our constitutional law. That's essentially what it is. We'll get onto that a little bit more in a bit more detail later on. The reader will no doubt come to the conclusion from this that the entire system of magistrates' courts is therefore unlawful and at odds with the British Constitution. Summary trial breaks all the principles of equity as there is no judgment by peers. Now this is a bit tricky because they'll claim in the establishment that your peers are the magistrates, but that's tricky argument for them to make also, because quite often they'll put judges in there too and substitute out magistrates. The following quotation reveals the secret behind the phrase consent of the governed. Okay, so this is again a quotation from Lysander Spooner's 1852 essay on trial by jury. And again, it's taken from Ken Dewdney's inclusion of the essay in Trial by Jury, its History, True Purpose and Modern Relevance, page 120. That's not Democracy Defined, the manifesto that Ken Dewdney wrote. It's his other book. And the reason why I say that is because he's got editorials in here as well, which are quite useful. The conclusion, therefore, is that any government that can for a day enforce its own laws without appealing to the people, or to a tribunal fairly representing the people for their consent, is in theory an absolute government irresponsible to the people and can perpetuate its power at pleasure. Wow, so clear. The trial by jury is based upon a recognition of this principle and therefore forbids the government to execute any of its laws by punishing violators in any case whatsoever, without first getting the consent of the country or the people through a jury. In this way, the people at all times hold their liberties in their own hands and never surrender them, even for a moment, into the hands of the government. Okay, so, wow, I mean, there's a lawyer in America, okay, writing this in 1852, explaining, of course, quite clearly that is the mechanism by which the people hold their liberties, because they are in ultimate power over the legislation, over the law. Yeah, it's pretty profound stuff, you know, and that's the end of that bit, because we're getting on to what that means to things like the legislature and the government's own law-making powers in the legislature. I'm going to get on to that later, and all sorts of other things to do with Magna Carta and so on. But that's the end of that section. I hope you'll agree that that is pretty profound, and importantly, that without that mechanism of full, authentic common law trial by jury, the Constitution doesn't really amount to much. So people who talk about the English or the British Constitution but don't include this, in my view, they're kind of missing the whole point, actually. And there are many that are doing that. So keep that in mind. That's the central pillar, if you like, of this. And then we'll get on to talk about the implications of this for the rest of it. But that's great. Thanks for watching. And see you in the next one. Cheers for now.